Joining us today are Anthony Wood and Kate Jenkins, partners at Freehills, who will be speaking at IIR's Sexual Harassment in the Workplace Forum, which takes place on the 6th and 7th of December 2010 in Sydney. Hello, Anthony and Kate. Thanks for joining us.
Yeah, great to be here.
Thanks.
First of all, what's the current state of sexual harassment claims in the Australian workplace? Are they reducing? And how does it compare with other nations?
Well, it's a hard one because we're always kind of operating in a delay and lag on the data, James. So, in one sense, it seems that the data is indicating that there is a decline in the gross number of complaints that are being lodged in, say, the Australian Human Rights Commission, and that pretty much reflects a decline in complaints in respect of sexual harassment claims that are being lodged in the US, and also to the extent we can get accurate data in the UK. Everyone kind of uses different indicia to filing and collating their data. But I think it's fair to say that there's a decline in the number of cases which are being filed, although anecdotally, there's a much greater emphasis on resolution of claims at the coalface, and there's a much greater notoriety of, obviously, claims and options that employees have to resolve their grievances. And as Kate would point out, a huge emphasis on the issue in the workplace means that employees are much better informed and obviously much better trained.
And how do consensual relationships at work intersect with sexual harassment laws?
The reason they intersect is the tension that exists because sexual harassment is sexual conduct that is unwelcome, and consensual relationships are obviously sexual conduct that is welcome. So there is a natural tension in this area of law which is not present in the discrimination area or other areas. There's also an issue because of the prevalence of relationships that do develop through work. So the sorts of intersections there's always a question about whether the conduct involved is work or personal conduct. It can be outside of work, or is it at a work social event? There's issues about the early stages in a relationship. Is it flirting or is it unwelcome? And there can be issues at the end of a relationship where one party perhaps no longer welcomes the conduct, but the other one is still pursuing the interaction with the co-worker. So there's a number of moments in time where that sort of personal relationship can hit up against the sexual harassment laws. And
when does employees' private life become an employer's concern?
Basically when it impacts the working life. So the laws cover work-related conduct which can extend outside the normal working hours, so sexual harassment laws and discrimination laws, work cover laws, bullying laws. It also impacts where the intimate relationship impacts work, where there might be a conflict of interest of an employee, there might be a risk of disclosure of confidential information to a competitor or to a customer. There might be favouritism, so it's where it impacts the working life.
Have you found company policy regarding sexual harassment has changed in light of the David Jones case, and should employers be worried if they don't have a solid policy in place?
They should be worried if they don't have a solid policy, but I don't think recent events have changed the policy position as much as raised awareness of what should have been in place already. So you need to have up-to-date policies. You need to have good, real examples that employees understand. You need to have training in place. And what's really become the focus is management, and the most senior people need to be aware of what's going on and know how to take action if there is potential breaches of the law.
I think if I can add on that, the DJ's case demonstrates one thing, that the extent of knowledge amongst boards of all of Australia's major companies will have been significantly enhanced by this, and they will all be asking to do a review of their own policy and compliance, and that's a good thing.
You're speaking at IIR's Sexual Harassment in the Workplace Forum 2010, which takes place on the 6th and 7th of December in Sydney. What will you be addressing in your presentation?
We'll be talking about looking at that distinction between welcome and unwelcome conduct, between work and private conduct. We're going to be talking about what the issues are in terms of employment, both where relationships happen or don't happen, and we'll particularly be looking at what employers have as options to address these sorts of issues, both looking at proactive things that can be done, including looking at what they're doing in the US, and what can be done reactively when the situation arises that you've got a claim or you've got an issue that's come up.
And finally, what would you like delegates to gain from attending your presentation?
Well, I think anyone who attends this session should really have a really practical understanding of the types of different approaches that companies have both in Australia and abroad, and really to gain some knowledge that if you don't have a policy or a means of dealing with that, and it doesn't need to be a draconian means, that there are consequences, and the consequences can be significant, and really how you can respond to those particular consequences, even where you do and don't have policies.
Anthony Wood, Kate Jenkins, many thanks for your time today.
Thank you.
Thanks a lot.